By popular demand, Debbie Reynolds Consulting is now offering executive briefings on emerging data privacy risks and how companies can avoid them. To learn more, visit the executive briefings page on my website. Thank you. The personal views expressed by our podcast guests are their own and are not legal advice or official statements by their organizations. Hello, my name is Debbie Reynolds. They call me the Data Diva. This is the Data Diva Talks Privacy podcast, where we discuss data privacy issues with industry leaders around the world with information that businesses need to know now. I have a very special guest on the show, a fellow Chicagoan and someone that I've had the pleasure with collaborating with over the years. This is Michael Booden. He is a senior technology counsel. Welcome.
Thank you, Debbie. I'm very excited to be here.
Well, we've known each other for many, many years. We've spoken on panels together. We just run into each other at random events in Chicago. So we saw each other recently in Chicago at an event where both of us were speakers. And I'm like, hey, why don't you be on the podcast? And you're like, oh, I'm happy to be on. So I love your work, the way that you prepare for things, because you and I were speaking that day and you had all your copious notes with you. But also, I think the thing that fascinates me about you is your interest in privacy. So I know that your focus a lot has been in contracts, but then also you've had to pivot or expand your work as it relates to technology and contracts. And so that may cover data privacy and technology. But give me a picture of your trajectory. How did you get to where you are now? And then how did privacy pique your interest?
Absolutely. So when I was in law school, I thought that I wanted to be a trial lawyer. And but the one thing that I really enjoyed the most in law school was writing. So whenever I got a chance to draft a brief or a motion in a writing course, I got very excited. And it was a way of at least demonstrating your skills. And I was fortunate enough to clerk for 2 law professors. So somewhere there are 2 review articles, and I'm a footnote in each of them for doing research and doing a little bit of writing for the law professors. And that led to me being chosen to be a clerk on the Illinois Appellate Court. And so I clerked for Illinois and ultimately a Supreme Court Justice Stamos. And so my first year after law school, I was writing judicial opinions that are still in the books today. I learned how to think like a judge in that role, and that has served me well throughout my entire career. After I finished my clerkship, I joined a firm and would go to court and was very excited about the potential to be a trial lawyer. But then I found out that these cases were so significant in terms of their complexity and the amount of money at hand that it would take me 5 years before I actually tried a case. So I ended up going to a smaller firm where I could go to court and represent individuals. And I learned to do commercial litigation and other kinds of litigation. And of course, to write. That was always something that was very much desired. Wherever I went, people wanted me to draft motions for them and briefs because they knew that was a particular skill that I had. And ultimately, I was representing companies in employment discrimination suits when I got the opportunity to go in-house. And I became general counsel of a university whose biggest school was a medical school. And that's where I got introduced to other aspects of the law, such as drafting policies for the organization, conducting internal investigations, but also drafting contracts. And I remember the day that someone handed me a contract, and I thought, this is very interesting. I wonder what you do with such a thing. And all I knew is that the contract shouldn't be vague or ambiguous. And I had learned that from some commercial litigation I'd been involved in where the language was vague or ambiguous. And that was an important thing for me to know, but there was a lot more for me to learn. So over the years, I basically self-taught myself how to draft commercial agreements, whether they be simple or complex ones. And ultimately, this led me to an interest in privacy law, and I became SIP certified through the International Association of Privacy Professionals, both in U.S. privacy law and European privacy law. because I realized in drafting negotiating technology agreements, which has become my specialty, that was an essential skill set that I need to develop. I needed to learn about the laws and weave them into the contracts I was drafting for my clients to protect their employees, to protect the clients that they were serving. And so privacy has just been something that has been on my mind for many, many years, and developed my skill set essentially in terms of drafting and negotiating contracts sufficient that for 13 years, I've been an adjunct law professor at the University of Illinois School of Law, where I teach a writing course to third-year law students on how to draft and negotiate commercial agreements. Now, I still use my litigation skills when I'm drafting and negotiating agreements because I'll sometimes have conflict with a vendor, an attorney who's representing a vendor, and he or she will say, well, this is what this means. And I said, well, I know what you think this means, and I know what you think this means, but what is a judge going to think it means? The language in the agreement can't be vague or ambiguous. It's got to be something that the judge understands. And I'm a member of what's called the Federal Bar Association, and most of the lawyers there are trial lawyers, but I've always liked their CLE, and it's the meetings that they have. We have an opportunity to meet federal district court and appellate court judges who sit on the circuit court in Chicago, the Seventh Circuit. And I met one of the judges, Rebecca Pallmeyer. She's, I believe, on senior status now, but at the time, I think she was a chief district court judge. And I told her what I did, and she said, so you don't want the language to be vague or ambiguous. I'm like, yes, Your Honor, that's exactly correct. So the first thing that I knew from litigation is served me well throughout all of this. And also one of my first meetings at the Federal Bar Association, I ran into a magistrate, Judge Kim, and I used to litigate matters before him. And I almost felt that he wanted to hug me. And he's from a different country and is not a very physically demonstrative person. But I used to file motions for summary judgment for him in front of him when he was an administrative law judge with the EEOC. And I would often get emails from him, and he would say, Mr. Booden, please send me the statement of facts in your motion for summary judgment in a Word format. Essentially, motion for summary judgment asserts that there aren't any disputed material facts, and therefore, based upon the law, the judge can dismiss the case. There's nothing really for the jury to decide in terms of material facts. And when he would send me that email asking me to send the statement of facts in a Word format, that's when I knew I was going to win the motion. And I would then, 2 or 3 weeks later, I'd get the opinion. And I have to say, Judge Kim is a better writer than I am. He writes wonderful opinions, which is why he's now a magistrate and was the chief magistrate in the Northern District of Illinois. But I helped him avoid having to try unnecessary cases. And so that's why he's so pleased whenever he sees me, because I made his life easier, which is what I try to do every day.
That's so cool. That's so cool. That's a great story. Well, tell me, how do you see privacy issues bubble up in agreements? I see this a lot, but I just want your thought.
Well, my core work is drafting, negotiating technology and commercial agreements, which really puts me at the daily intersection of data, vendors, and privacy obligations. One of the first things I did for my company is I drafted what I call a cybersecurity addendum. And the cybersecurity addendum essentially addresses terms that may not be fully fleshed out by the vendor. And it details the data security protections that I expect them to provide from an objective perspective in order to protect the privacy, the information that we're going to be transmitting to that organization. And I also cover, when I talk about my expectations of their data security protections, they're all objective ones. So ISO standards and NIST standards, ones that there won't be any argument about what our expectations are and what we, between parties, because again, I want it to be clear what we want and what we expect. And if they can't provide it, then we will find someone else. So while IT has their own way of vetting vendors from a technology perspective, and I'm not a technologist, but you don't have to be a car mechanic to direct traffic. And but from an objective perspective, there are all kinds of standards that the law provides to protect personally identifiable information, PHI, and sensitive personal information, and also the confidential information of our organization. So that's what this document was designed to do, and to provide us with indemnity protection if there is a data breach. So we hope for the best, but we plan for the worst, and data breaches happen. So this document allowed me to be not just reactive to the representations and warranties made by the vendor, but their promises to us, but then to be active in asserting what we need to protect our clients and our organization and our employees. And based upon that, I've now drafted other addendums. For example, I drafted an AI addendum, the same kind of concept where the AI vendors don't always particularly address the concerns that are necessary to protect the privacy and security of the information that we will be sending to that organization for processing and storage, and particularly related to outputs as well, and how that information will be maintained. And for transparency's sake, our clients at the organization, my company is an insurance broker, one of the fifth largest insurance broker in the world with 21,000 employees. Our clients started asking us, what are you doing with our data vis-a-vis AI? And so I drafted a client addendum that we now then send to clients that explains our policies and procedures in processing their data. So there's complete transparency between us and our clients, so they understand how we're using AI to process their data, and to provide them with adequate data privacy protections and data security protections. And the last document I'm going to mention is I drafted an amendment to our outside counsel guidelines that also addresses those same issues. How is the law firm going to utilize AI in providing us services? And one of the most important things is that you don't use consumer AI tools that don't have the proper data security protections in processing our data. We only want the data to be inserted into privately licensed tools. Our organization uses Claude. That's our basic general reference AI tool, but it's privately licensed. All the information we provide, that our employees provide, is protected. There's a ring around the fence. So Anthropic cannot use that data to train its tool. It can only utilize it to train tools that are dedicated solely to the organization. And and I know we have those protections in writing because I negotiated the contract with Anthropic.
And I think that's another reason why Anthropic's had this massive growth, right? Because people want to use the tools, but they don't want their information to end up in these public tools and be spit out, as because we saw this early on where people were using the publicly available tools and people were putting their company proprietary and confidential information in there, and people were able to prompt it and get that information out. And so
And we use that tool every day. I mean, more and more I think 60 to 70% of our employees have used Claude at least once, and at least 30% of them are high volume users. And they're coming up with new ways of using AI every day to make their jobs easier. And we're not looking to reduce positions. We want to empower people to be more effective and efficient in doing their job. So the low value work can be work that they can have Claude help them with, whether it's organizing information or providing specific information that has a direct impact on their job. And as a person who's taken a lot of depositions, I'm very good at asking questions. And what I've found using Claude is the more particular I am in describing exactly what I want, the better output I get. So, but it's been a great tool that we've been able to utilize to help our employees become more efficient and effective. And that's my hope, that more and more people, ordinary individuals, can get to that place.
I agree with that. One thing, I just want your thoughts on this, and this is my experience, but I want your perspective on this. So I know there are just so many, especially in the US, there are so many new states that are passing these privacy laws, and they are creating a lot of agita for companies trying to navigate all of that, right? But what I'm seeing is that because I work a lot with companies on technology and contracts as well, from a technical perspective, what I'm seeing is that companies like yours are pushing down requirements to third parties. And so these third parties, they may say, well, for example, let's say I don't do business in Europe, but you are a third party to a company that does business in Europe, or you're a third party to a company that has employees in California. So what I'm seeing from a contract perspective, companies forcing other third parties to align with what they have to do. And for me, I think that's probably even better than a person getting all tangled up in the law. So, because the companies can tell you this is what we expect, and they can make it more tangible and plain for them. But what is your thoughts?
Well, the first thing I want to say is that I agree with the sentiments that you've expressed exactly. But the first step in this AI journey for me was 2.5 years ago. I realized that our employees at some point were going to want to utilize AI to help them do their jobs, and that we did not have a policy for that. And knowing that there are these public consumer facing tools that have no protections for the information that you're going to be putting in terms of privacy, people put in their names, social security numbers, all kinds of information. And then that information is available to all others. I was recently giving a presentation, and someone said, well, how is it that the confidential information of my organization is exposed if I put that in an AI tool? And I said, well, think of an AI tool as a book. And now you've put that information on a page in that book. And your client's competitor may ask the same question and then get an answer based upon the learnings, the non-public information, the strategies of your organization that are now been inputted into that AI tool. So I decided that we needed a policy for our employees to address their use of generative AI in the workplace. And at the time, because this was such a new thing, there weren't any real forms I could just copy off the internet. So it took me 3 months of research and 2 months of writing. And the result was a 2.5 page policy addressing AI usage, generative AI usage in the workplace. And it was an immediate hit with the head of our IT department. And we adopted it basically as I've written it, and I made adjustments as we've gone along. But that's been the first step along our organization's governance process. And now we have an generative AI governance committee. I'm on that committee. I'm also an AI champion for the organization. And we have conducted training for employees on how to use Claude, as well as on the policy, the do's and the don'ts to protect our clients, their employees, and their clients' sensitive information, whether it be PHI or personally identifiable information. So, and then based upon that, I use that as a starting point to draft those other policies that I talked about, the AI addendum and the outside counsel guidelines for using AI, as well as the client AI addendum, which we provide if our clients request it. And so when we're asking our outside counsel, we're asking other AI vendors, whether it be Anthropic or OpenAI or hundreds and thousands of other AI vendors or SaaS providers that have an AI component. We're asking them to meet certain restrictions and goals and guidelines. These aren't things that we're not doing ourselves. We're just flowing down from our organization. We're flowing these restrictions, these guidelines, these requirements to comply with all these various laws. We're just flowing them down to those organizations that are supporting us and helping us provide services to our clients. But it's a very difficult process to put together policies and addendum like this because there are, as you mentioned, so many different laws. There's an email I get every day that keeps me up to date on all the new laws that are being introduced in all the state legislatures. And because my company has operations in Canada as well as the US, I have to pay attention to the privacy laws in all the Canadian provinces, whether it's British Columbia or Alberta. And I learned something I did not know, which is that if you want to buy auto insurance in Canada, you have to you're almost forced to buy it from the government. And the government policies often have these tools that you have to put in your car and so the government knows when you got in your car, how fast you drove, where you went to, all these details, very intimate, private information. And they have rules that dictate what you can and can't do with that information. The challenge for us is because we often will have input into Claude from our employees in Canada about Canadian residents. Most of these laws have restrictions that say that either prohibit you from sending this kind of sensitive personal information about Canadian residents outside the country or have significant restrictions on them. Well, Anthropic is in the United States. So if you're typing an input into Claude, it's going to America, it's leaving Canada. So in drafting policies for our organization, we have to take into consideration not only all of the state laws, whether it's Colorado or Oregon or Illinois or California, the country of California, as lawyers call it. We have to write these policies and procedures to that highest level so that we're able to protect ourselves from a compliance perspective. And my organization is considering issuing an IPO. So investors are asking us, well, what is your AI policy? What is your governance structure like? How do you protect the information that you're inputting into AI tools? So this is something that not only that your customers want to know about and your private investors, but public investors. This is now a check mark that 10 years ago didn't exist. Everyone wants to know what you're doing to protect their information and how you're using AI when you're involved in that process of
Right.
using it.
And it's funny because I think a lot of people say, well, we don't have AI laws in the US. I say, but we have data laws. And AI uses data. So data is the food of AI. So
Yes,
that means
exactly.
yeah, there is regulation. You may not think of it in the same way. And actually, I think it's smart the way that you're approaching it. And this is the way that I advise companies to approach AI. Early on, I saw a lot of companies like we're doing prohibitions, like you can't use AI at all. And for me, I don't think abstinence is education. So
It
yeah,
is, and the reality of it is that unless you're a one-person company, your employees are gonna wanna use AI. I use it every single day, and honestly, now I don't know what I would do without it. It just saves me so much time, but without careful restrictions on your employees' data, your clients' data, particularly that's already protected by state and federal laws, you're in danger of violating rights and not being compliant, and nobody wants to be in the penalty box.
totally. So what in the world is happening right now that's concerning you, like in the privacy or data space that you see? You're like, oh wow, I'm kind of concerned about this.
Well, I think you touched upon it that there is such a disconnect and variability between all the different laws in each of the different states. It really makes it, when it touching upon not only just privacy, but AI obviously as well, that it's making it almost impossible for individuals, even lawyers, to figure out what the jigsaw puzzle looks like on a day-to-day basis in order to be in compliance with all these different various state laws. And there's old joke that privacy lawyers talk about how there's going to be this federal privacy law someday. And we don't even talk about it anymore because we've talked about that joke so many times. It's just not even relevant because we know it's just never, ever going to happen. And EUAI Act, I think, has a lot of strengths, and in our state laws have been highly influenced by it, and our practices as corporations as well. We don't have that. And I think that it's impacting individuals on a daily basis. They don't know what their rights are. And because their rights are so disconnected, it's almost solely based upon where they live. They don't know how to protect themselves. And it, AI should be an empowering tool. I know that from talking to some of my colleagues at the Federal Bar Association, judges are using AI to draft opinions. And many of them are excited by the fact that there are pro se complainants using AI to previously do things that they couldn't do because either they don't know lawyers or they can't afford one, that they can use AI to draft a complaint and other court documents that they need in order to litigate a matter and represent themselves in court and then get redress for valid claims. But many people don't really know how to use AI. I think AI should be something that is taught, in elementary school as part of reading and writing, both the good, the dangerous, but then the beneficial aspects of it, how it can empower people to become artists and writers and scientists and in whatever profession individuals decide they want to explore during their lives. But without any teaching about both the dangers as well as the benefits, we're really creating this wormhole, which is very scary to me.
I agree with that. I think education, both of us are educators. So the education and knowledge is key for people to really be able to understand it. And I am personally excited about the fact that pro se litigants now can help themselves better than they were before. Because I know, especially with the formatting of documents that go to judges, it makes their jobs easier. Those things are formatted in a way that the judge expects. So I think that's very important.
Yeah. But again, every day you read about somebody being influenced by an AI tool to do something that's reprehensible. And it's just very sad. And I know children who they're glued to their phones and their computers. And you just say, you don't have no idea. God knows what they're doing and how they're interacting with these games and tools. How does that affect them? And that's why lots of schools are saying, well, you've got to put your phone in bag and you can't use it during the time you're in class. And even the class that I teach at a law school, I tell my students, you can use a laptop. I understand that you want to take notes, and I'll have typically 14, 15 students in my class, but I'll tell them if you're doing something else on that computer, I will know. I'm paying attention. And when you're laughing and I haven't told a joke or done something, crazy, it's kind of a tip off. So class participation means you're focused in the class not only to help yourself, but to help others because this is an interactive enterprise. We're all learning from each other.
I want your thoughts here. Now, especially when generative AI first burst out into the scenes with people, I know a lot of educators were concerned about people using AI in their class. And for me, I was never concerned because I was like, the things I'm going to ask you, AI cannot help you with. So, I'm not asking you if George Washington chopped down a cherry tree, right? So that never concerned me. But what are your thoughts or what do you tell your students? I'm curious.
I discussed this the first day of class. We talk about basically everything they're going to learn and how they can succeed and how I'm going to grade them and what we're going to cover from a subject matter perspective. But I spent a significant amount of time talking about the use of AI to um, pr- answer homework in class. At my school, the use of AI in producing homework, it's an ethical violation. And I'm very clear to them that this is something that is not acceptable. And if I believe that they've used AI to produce homework, then I will alert the dean and they will have a very, very uncomfortable and difficult conversation. And that is not something that I want for them, as well as failing my class. AI, at least in my profession, for me, it's a great tool, but I developed instincts and I've learned a few things in drafting and negotiating thousands and thousands of agreements. And an attorney who hasn't developed those instincts, hasn't sorted out what's best for their client, to fish from the fowl, the AI tool, they have no idea how to evaluate that output. When you're riding a bike, you're going to slip and you're going to fall, you're going to skin your knee. It's an experience. You learn from that experience. And the same as a law student learning how to draft and negotiate contracts for a partner or for a corporation when they're asked to do so. They may get a great answer from Claude, but they won't necessarily know why that is a great answer. And they won't know when they're getting an answer that isn't correct because they haven't developed that instinct themselves because they haven't jumped on the bike and fallen off and learned how to ride the bike the right way. And I also tell them, because they may be marking up and negotiating a non-disclosure agreement or a master service agreement, a statement of work, an agreement that a corporation or a corporation is asking a vendor to provide services. The final is even interesting. I have them draft and negotiate a G Suite agreement. So I pretend that one student represents the university that's interested in getting the G Suite, Google Docs, and Google Sheets from Google, and the other attorney represents Google. And I utilize a template that I get off of the internet from Google. And I could learn how to negotiate those kinds of agreements by just getting an answer. And I also tell them I run all these assignments, the documents that I've given to you, the questions that I'm asking of you. I've utilized all these tools. So I know what the tools are going to say. So when you give me an answer that's produced by Claude or Anthropic or ChatGPT or Gemini, I'm going to recognize every single word of it. So that's, if you're just looking for an answer, you're wasting your time taking this class. We're here to learn.
Right.
And utilizing these tools at this stage of your career is just not appropriate. And it
Yeah.
won't help you other than perhaps get a better grade or perhaps not get a grade that
Oh
you
my
don't
goodness.
want.
One thing that you touched on that I wanted to talk with you about a little bit more depth, and it's actually something that I've seen over the years a lot in privacy, and that is the influence of the European laws or frameworks on us in the US. Even though we don't have a comprehensive privacy federal law, the European laws are influencing us about how states are looking at things, how corporations or companies looking at things. Because in my view, it's like if someone has a choice to look at a framework or look at nothing, they will look at a framework. That as a starting point. But what are your thoughts?
I think the facts speak for themselves. I mean, the concept of a controller and a processor comes from GDPR. And without that concept of who controls the information and then the party that or organization that processes that information, we wouldn't have that without GDPR. So just as GDPR has influenced California and other states and federal organizations in drafting and legislation that we all must comply with, the different sectors, like the New York Department of Financial Services, which affects our organization because we're considered as an insurance broker, a finance organization. They have all kinds of guidance on adequate data security protections to protect your client's information. And we have to notify them within 72 hours of a data breach. So there's a whole regime. All of these structures, whether from California to New York and all the states in between, they've been influenced by GDPR and the same with the EU AI Act. I believe that has had a significant influence on the laws that legislators are proposing and those laws that have passed.
I think so too. So that's the irony of it, really. So I know there have been a lot of talk about, oh, we don't want AI regulated because we don't want to stop innovation. And it's like, well, it is regulated in some places, and because there is no other place to look for a framework, people are heavily looking at the EU AI Act as they had with the GDPR. So I think it'll just continue that way for now.
Well, I think the facts speak for themselves. I think if you look at organizations that are part of the AI pipeline, from the companies that make the processing chips to the data centers to the companies themselves like OpenAI and particularly Anthropic and even Google with their Gemini tool, they're thriving and organizations are adopting and utilizing their tools every day. With 21,000 employees, we are one of Anthropic's largest single clients, and we are thrilled to have them as part of our team. And so the facts really speak for themselves. Individuals are using AI, organizations, corporations are using AI, the government is using AI. So on one hand, the government might say, well, we don't want to use Anthropic because of some security issue. And then you have other parts of the government saying, oh, no, we need this in order to do our jobs. And the Department of Defense has been using Anthropic, and I expect other AI tools in the conflict in Iran. So the facts speak for themselves. We're not the government, individuals, corporations, we're using AI, and the lack of regulation hasn't stopped us, and nor has the regulations that we have to comply with. We just have to follow, the roadmaps that we're given. And because there's no universal law, which is, I think, is the big hole, that would really be a next big step forward for all parties.
Well, that's a good segue to my next question. So, if you're the world according to you, Michael, and we did everything you said, what would be your wish for privacy anywhere in the world, whether that be regulation, human behavior, or technology?
Well, I really think it's just the thing that I've already mentioned. I think the use of AI in particular, it has great benefits for individuals and for organizations, but particularly for people on the street, we really need to provide them with education so they can utilize AI to their benefit and find ways to avoid the negative influences that it has, particularly on our children, who can be easily influenced by a tool that really, 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 really wants you to like it. Every single time you ask a tool to provide you with output, it's going to ask you, how can I help you in other ways? And it'll suggest ways, but they really want you to be connected to it. So there are dangers in that. And there are no parents that are monitoring this sort of thing hanging over children's shoulders 24/7. So if it was the world according to Michael, we'd have consistent regulation that would apply to all individuals in the United States. The Congress could get their act together and come up with reasonable compromises that are comfortable with industry and corporations and with individuals and rights groups, as well as having education of our children on how to utilize AI in the best manner possible, and regulate the AI tools so that there has to be ways for these AI tools to sense when an individual is in real trouble and seeking answers in ways that are going to harm other people. The first rule as a physician, and it also applies as a lawyer, is do no harm. So that really has to be a guiding post for the organizations that are providing these AI tools. And I'm not sure that it is. I certainly
Yeah,
haven't seen it articulated anywhere.
that's a good wish. I wish that as well. Oh my gosh. Well, thank you so much, Michael, for being on the show. This is fantastic. I really enjoy your work and enjoy collaborating with you, and you're wonderful. So thank you.
Well, the feeling's mutual, Tabby. It's been a real honor to be on your show, and I'm a huge fan. I listen to it all the time, and I learn things, which is fantastic. Entertaining and educational. You don't get better than that.
Oh my gosh. Thank you. Thank you for the high compliment. I really appreciate it.
Well,
But
it's well deserved. I'm a straight shooter.
you are totally, totally, totally. Well, yeah, thank you so much for being on the show, and I love the deep dive on the contract stuff. I think it's fascinating. But thank you again.
Thank you, Gabby. My pleasure.
All right, talk to you soon.
Bye.
Bye.